This is E2B, Energy to Business, a podcast by Opportune, where we bring you in-house expertise that serves all energy sectors. We examine emerging financial and technology trends and provide a broad perspective on ways to stay ahead, create opportunities, and execute market strategies.
Hello, everyone, and welcome to another episode of E2B, Energy to Business, an Opportune podcast. I'm your host, Daniel Litwin, the voice of B2B, and folks, thanks so much for joining us on another episode of the show as we continue to explore major trends, strategies, technologies, you name it, the most important conversation starters for the larger energy industry. As we explore today's talking points, make sure that you are all caught up with previous Opportune research and content. You'll want to head to our website, opportune.com. Again, that's opportune.com for more information on our solutions and services, for more articles and research, especially around the topic we're going to be breaking down today. You can also find other episodes of E2B on our website. You can also find other episodes of E2B on Apple Podcasts and Spotify. So just hit that subscribe button, look up Energy to Business, and you'll find a full catalog of previous conversations, as well as notifications when we drop new episodes. So for today's episode of Energy to Business, we're going to be laying out some strategies for maneuvering the various options out there for taking your company public. Now, you might think, yeah, IPOs, we know how to maneuver an IPO. We're familiar with an IPO. However, we're going to be expanding on a recent Opportune article to draw some comparisons between IPOs and SPACs, special purpose acquisition companies, as well as MLPs, master limited partnerships. And what we're going to do is, in comparing all of these, we're going to learn whether SPACs could potentially take a page from the MLP playbook. We're going to dig in a little deeper to make sure you fully understand that word salad there, but there are a lot of important insights to be drawn from this compare and contrast. Now, as an initial sort of introduction to some of these concepts, IPOs, as most companies know, are the most common way to raise funds from public investors. This is via creating and selling stock on a public exchange. Easy enough, right? We also have SPACs, which functionally act as shell companies and go through a similar IPO process, but since they're created solely to merge with the, quote unquote, true private company after raising said capital, they have little assets they need to disclose in their initial public offering, nor do their operations impede or slow down that process as much as a fully fleshed out company. On top of that, you also have MLPs, which are pretty unique to our industry and the real estate industry as well, and are publicly listed private partnerships with the tax advantages of a partnership as well as the liquidity advantages of stock. So there's a lot there, but we're going to draw those comparisons and we're going to better understand how can SPACs be a further useful strategy for companies in the larger energy industry. So for insights today, we're joined by Mr. James Hanson. He's Managing Director for Opportune Partners, which is the broker-dealer affiliate of Opportune. James, welcome. Great to have you on, man. How are you doing?
Thanks, Daniel. Always good to be with you.
Yeah, it's a pleasure getting to chat on this topic. As I mentioned in the introduction, there is a full Opportune article on this subject that I recommend folks go check out. It's titled, "Should SPACs Take a Page from the MLP Playbook?" And this was something that you wrote and contributed to. So we'll link to that in the description of the podcast. Now, before we get into the main topic, James, let's get a little background on you, make sure folks understand the perspectives that you're going to be adding to the conversation today. So if you could just give us that elevator pitch, that executive summary on your background and your career path, but more specifically, some touch points that you've had with this world of IPOs, SPACs, MLPs, kind of how that informs your perspective today.
Yeah, thanks, Daniel. It's pretty simple, really. I've been covering the energy sector in the investment banking context for basically my whole career, about 30 years. Started out mainly in the bulge bracket, focused on mostly the infrastructure side of the energy sector, which included a lot of master limited partnerships. And then for the last kind of second half of my career, I would say is mainly been a board advisory and looking at transactions through the lens of fairness and solvency and, like I said, board advisory. So run into a lot of conflict situations over the years, which was the impetus for this this topic.
Perfect. Well, thanks for that background and information there. Let's get into the main topic then, like you said. I'll harken back to my definitions during the introduction. Those were very high level, and I want to give you an opportunity to expand on this. But again, as an alternative to IPOs, special purpose acquisition companies or SPACs also get referred to as blank check companies. We've also seen them grow in popularity in recent years. So in 2020, just to give you some numbers, according to some Bloomberg data, 248 SPACs were created with about $80 billion invested. That was in 2020. In 2021, there were a record 616 SPACs created, representing nearly $163 billion in capital raised. So almost, 4 times growth when you look at the number of SPACs, and then 2 times growth in terms of how much actual capital was raised. So let's get that definition out of the way. I did a very simple job, but expand for our audience here for us. If you could just explain what a SPAC is and the purpose that it serves in this larger ecosystem.
Yeah, sure thing. I think your explanation was a great start. And honestly, a blank check company is a really good way to think about it. A SPAC, like you said, is really formed and IPO'd without a specific business in mind. It's really just the promise of finding and acquiring a business. And so people are essentially backing the sponsor, the people or management team that's going to be out there looking for opportunities. And the way a SPAC works is it's really 3 steps. So the first is the sponsor team forms the SPAC with no specific business or target in mind. And like you said, goes through an IPO process where they issue shares. Usually it's $10 a share, kind of an arbitrary amount because you don't have a specific business in mind, and raises a certain amount of capital. As part of that process, the sponsor will get what they call founder shares, which are, essentially free shares in the SPAC that go along with that. And then the second step in the process is the SPAC has 2 years to go out and search for a potential business to acquire. If they don't get a business during that time period, if they fail to acquire one, then basically the shareholders end up getting their money back. All the funds from the original IPO were placed into blind trust and will be returned if an acquisition doesn't take place in typically 2 years. So during that 2-year process, they'll identify an acquisition, negotiate with the potential acquisition target, which is a unique aspect in terms of taking a company public. A lot of companies would like the fact that you really have a lot more certainty in terms of how your business is going to go public and what the valuation is going to be. But once that negotiation has taken place, then the SPAC sponsor will present the SPAC via proxy statement to the shareholders, and there'll be a shareholder vote. And so the shareholders can vote either for or against the transaction. And then separately from that, even if the transaction is approved, if there's a shareholder that doesn't like the transaction and isn't happy with it, they have redemption rights where they essentially get their money back plus some nominal interest. So it's a very low, for original investors in a SPAC, it's a very low risk way to potentially, sponsor to back a sponsor in terms of looking for an acquisition. Mm.
So when you compare that to the tried and true traditional IPO, what makes a SPAC an attractive proposition or option for going public? Is it because of the expediency? Is it because of some of the removal of red tape compared to taking a more fully established company public? What do you see as the main motivators, or I guess how would you vouch for a SPAC compared to an IPO?
Yeah, that's a great question, and I think your question highlights why a SPAC from the context of a company's point of view. Why would you merge with a SPAC rather than go public? And I think you hit two of the big ones right on the head. Certainly expediency is one. You could just think about starting a company from taking it from a private company to an IPO is a very long process and a very expensive process in the context of, you can take up to 2 or even 3 years for a traditional IPO, whereas a typical SPAC, de-SPAC transaction, as they call it, takes about, usually 3 to 4 months. The regulatory aspect is definitely a piece of it. Although the fact of the matter is the regulatory aspects don't completely go away in the context of a SPAC, but the actual IPO process and what the IPO documents look like are a lot more straightforward. But if there's any like if it's FCC regulations or antitrust or anything like that, I mean those kinds of regulations all still apply. But certainly from the IPO standpoint, it's a lot easier. And then I would say probably the most attractive point that people usually point to is the fact that it's a certainty in terms of where your valuation is going to be, what the success is going to be. I mean, the shareholders could vote down the SPAC, certainly. But, if you think about a typical IPO, investment bankers set the price where they think the right place is going to be, but it's not uncommon for IPOs to pop, 50% after the IPO, or alternatively, it could be, a lower amount. And so therefore, if an IPO pops, the company's, pre-existing shareholders are really leaving money on the table, and, and vice versa. It could be a risk for investors. So companies really like the fact that you can negotiate with the SPAC sponsor, determine the price, set the economics, and then take it to market with that set level.
Well, then it sounds like there are reasons to leverage both. However, I'd imagine companies are probably more familiar with the legal intricacies of maneuvering an IPO compared to a SPAC, considering it's really, as a means of going public, just now gaining this kind of steam it needs to become a standard. So I want to highlight, maybe one component of a SPAC that was either, recently challenged or, was given a new layer of legal intricacies. So there was a recent Delaware court ruling that found that despite the SPAC's shareholder vote and redemption feature you were mentioning earlier, there was actually an inherent conflict between the SPAC founders and directors, because the founders' shares would inherently be worthless in the absence of a de-SPAC transaction, and that this could create a potential incentive for the recommendation of a transaction that was worth less than the redemption price. So that's a pretty layered dynamic in and of itself. Can you expand on this dynamic for our audience? Get a little bit more specific on what this actually means, and explain what the implications of this court ruling could have on this quote entire fairness standard.
Yeah. I think that's a really, it certainly has been getting a lot of attention in the SPAC world. This court case, you're referring to the multi-plan shareholder lawsuit, where it wasn't, the case itself wasn't settled, but what was decided by the Delaware court was whether or not certainly the defendants, the multi-plan participants, asked the court to dismiss the charges. And the court ruled that they were not dismissing the charges. And what was particularly, as you alluded to, particularly interesting in this case is that they really advocated the application of the entire fairness standard. And maybe taking a really quick step backward just to understand what that means for, really kind of almost all time, at least in the United States. And this even harkens back to, Old English law. Managers and directors of companies were judged from a fiduciary standpoint, from a legal fiduciary standpoint, based on what has been known as the business judgment rule. And the business judgment rule is really just basically saying that if a manager or director operates in good faith, then they won't be held liable for the decisions that they make on behalf of shareholders or fiduciaries. And so in 1983, there was actually a court case called Weinberger versus UOP, where the Delaware court introduced this concept of entire fairness. And that was a case where there was a conflict of interest between the chairman and the shareholders. And basically the net of it is that entire fairness in the context of the court decision basically said that if you had a controlling conflict, so if you had a person who was, defined as a controller of a transaction, and there was a conflict of interest, then the decisions related to that decision were held to a higher standard. It wasn't just, whether or not you, used good faith. It really kind of anchored on two things: whether the transaction was, fair from a price standpoint, but not only that, but was the transaction fair in the way that it was dealt with? Fair dealing is what they call it. And so that could be, how was the transaction presented? Who made the decision? What was the process that went into that decision? What discussions took place? What negotiations? I mean, it's a much broader view. And lawyers hate it when you have to have a lot of those subjective type things that go into a legal standard. So, so that's an area that was really, people really took notice when the Delaware court said that this multi-plan SPAC suit would be judged under the entire fairness standard.
So then do you think this means that it will become a prudent legal protection going forward to seek some kind of fairness opinion? Or I guess, what do you see as the consequences moving forward, just in general?
Yeah, a fairness opinion is actually a great way to protect against things like that. So if you're thinking about a potential conflict transaction where, both price and process are in question, and you're a decision maker or a person who's, trying to protect against that, hiring a third party and providing a fairness opinion can be a really good protection. It's used over the years to do that. It's not really just a piece of paper that says, yeah, the transaction's fair, but if a fairness opinion, if done correctly by an independent party, has, behind it a lot of due diligence, a lot of questions being asked, a process in and of itself where, details of a transaction are explored and looked at, and, really with from a lens of a non-conflicted third party. So that can be a really good way to protect against conflicts of interest.
So to bring in another layer now of potential strategies for going public, I mentioned this in the introduction as well, but we also have MLPs, master limited partnerships. And from a conflict standpoint, I guess playing off of the Delaware court ruling we were just speaking on, MLPs and SPACs have some similarities. At the highest level, like I said, MLPs act like publicly traded entities, though they're taxed as partnerships, which companies can often see as a win-win. Now, in terms of the conflict standpoint, or even at the highest level, just comparing the two strategies, what are some things or maybe some pages that SPACs can take from the MLP playbook? Is there anything of note here that you think could improve a SPAC's viability?
Yeah, that's a really great point. MLPs and SPACs certainly, at least in my opinion, have a lot of similarities, and the biggest of which is that both are formed typically via a relationship with a sponsor. So a SPAC, obviously has to be formed via a sponsor. MLPs were often formed as publicly traded partnerships via another either private or public company. And the typical business model within an MLP was that assets at the sponsor would be sold to, or the term was dropped down to the MLP. And each of those transactions would be potentially very attractive to the MLP, but could also be viewed as a conflict transaction because the sponsor or controlling entity for the MLP is the sponsor. So they're on both sides of the transaction. They're selling assets and they're, negotiating for the MLP to buy assets. Now, one big difference between SPACs and MLPs is MLPs are not publicly incorporated companies. Like you said, they're partnerships. So their fiduciary duty is defined by their partnership agreements. But over the years, MLPs have become really smart about that and have defined how they're going to look at these conflict transactions within their partnership agreements. And almost universally, the way that most MLPs set out that they're going to look at these is through something called special approval. And a special approval basically means that they're going to form a special committee, or sometimes they call it a conflict committee, of the board of directors, independent members, and that those independent members will deliberate and typically hire their own advisors and their own advisors, legal and financial, and they'll get a fairness opinion. So that process has been fairly successful, barring a few very specific examples, but been very successful in protecting MLPs against claims of conflicts in the context of drop-down transactions. And so the thought here is that, this could be something that would be very attractive to SPACs. I mean, typically SPACs a lot of people have thought of SPACs in the context that you don't necessarily need a fairness opinion or need a special committee review, because you have two pieces of structural protection that most practitioners or observers have felt would cleanse conflicts. And the first is the big one, the shareholder vote. That's common across a lot of different conflict transaction, is that if you have a shareholder vote of the uninterested parties, that is something that could potentially cleanse conflicts. The other is the repurchase right. So if you're not happy with the transaction, you can repurchase it. But again, this multi-plan decision or preliminary decision really calls into question some of those protections and whether or not kind of the belt and suspenders of a independent committee and fairness opinion could potentially bring to SPACs.
Well, luckily for SPAC target acquisition management teams, protection from these kinds of legal challenges and potential conflict transactions is already a well-traveled path in Delaware case law. I'm curious if you can give some more examples for our audience so they can really contextualize that full scope. But can you briefly explain some cases that have held precedent and why an independently provided fairness opinion provides the optimal kind of protection against these legal challenges instead of, maybe draw some comparisons to non-independently provided fairness opinions?
Yeah, that's a good question. Actually, you're right. This is a very well-traveled path. It really harkens back all the way to 1985. There was a Delaware case called Smith v. Van Gorkum, where the court found that the directors were negligent in their review of and approval of a transaction that involved a conflict of interest. And the court specifically said in their decision that the directors could have mitigated these claims of negligence by obtaining an independent fairness opinion. And so really from 1985 until today, fairness opinions have really become the gold standard in terms of protecting against conflicts of interest in these kind of control conflict transactions.
So then in summary, what might be some other things that people should know about SPACs? And to keep the Delaware court case front of mind, what else should people know about how that latest Delaware court ruling could have some implications on transactions and how they'll be eventually evaluated in the future?
Yeah, that's another great point. And the Delaware court in Multiplan was very specific and careful to mention that wasn't simply the fact that there was this control conflict situation that made them make this decision. It was like a lot of court cases. It was kind of a mosaic of a lot of different things, not the least of which was the fact that the proxy materials failed to disclose a very important piece of information. The fact that, one of Multiplan's largest customers was considering doing what Multiplan does, but in-house. So the loss of that customer, would have been a material piece of information that shareholders would have wanted to evaluate in the context. So that was certainly a piece of it. But again, from from my perspective, as I look at it, why not go through the rigorous process of reviewing a transaction from a third party or independent viewpoint in order to really make sure that your belt and suspenders covered in terms of potential conflicts of interest.
All right, James, those are the core insights that we wanted to break down on the podcast today. What I want to do is pose up a last question that's a little bit more strategic here, just to wrap things up. So we've touched on and reviewed how IPOs compare to SPACs. We've also compared how SPACs relate to and can even draw influence from MLPs. If you had to lay out sort of a summarized strategy for when to implement each in the current context of our industry today, could you lay out some of that advice or draw, the pros and cons of weighing each in a going public strategy?
Yeah, I think that, my thoughts with regard to multi-plan are really just more, how could a SPAC protect themselves?
Sure.
But you do bring up a good point. I mean, really, MLPs are very specific because the assets that can be put into an MLP are defined by the tax regulations. They have to be qualifying assets. So from that standpoint, most people or most companies would really, look at it more from the standpoint of IPO versus SPAC. And, while this multi-plan decision, does create some uncertainties in terms of, you potentially needed to protect against these conflict of interests, especially over the course of the pandemic and a lot of the uncertainties that have kind of surrounded the IPO market, companies have really looked to SPACs to say, this is a way where we can get a little more certainty vis-a-vis a very, conflicted market or a very, volatile market. That being said, the SEC and others are, people are taking a hard look at SPACs given this huge boom of growth over the last few years. In fact, the SEC just last month came out and said that they're reviewing the rules that have to do with the initial public offering documents. Typically, in an IPO, you can't use forward-looking statements. But under safe harbor rules, if it's not an IPO, you can use forward-looking statements in your disclosure statements. And so, SPAC proxies, de-SPAC proxies, I should say, the merger, the documents that describe the merger usually include forward-looking statement, which is a huge benefit to companies who, especially are earlier stages, as sometimes SPACs have tended to be more almost leaning towards the venture side of the world, have used forward-looking statements to say, this is what we expect to our company going forward. So the SEC may put restrictions on that going forward, which would potentially limit some of those types of companies. So a lot of moving pieces. But certainly, I would be surprised if some of the time elements and the certainty elements of SPACs didn't continue to remain attractive for a lot of companies looking to go public.
And then to keep it back on the legal protection side, if you had to lay out some strategies for how companies can start to lay that legal protection groundwork in a way that is conscientious of the value of each of those going public options, right? And do you see strategies for developing those legal protections needing to necessarily be siloed to protection strategies for MLPs, for IPOs, for SPACs, or is there crossover there that can inform a more holistic strategy?
Yeah, MLPs, like I said, certainly have a very defined strategy. This is tried and tested over years and years. IPOs are, kind of by their definition, have a certain level of protection just by the fact that there's, extensive disclosure about the IPOs themselves and rarely a conflict of interest in the context of an IPO. But the SPAC, given the fact that if a SPAC doesn't take place, the founder's shares are worthless. Again, taking multi-plan to a kind of a further level down, what the court was concerned about is that even if the transaction would be potentially value destructive versus $10 a share that the shareholders could redeem their SPAC shares at, versus a transaction that would be potentially worth less than that. It's definitely a conflict of interest, because anything is worth more than nothing to the founders, where anything less than $10 would be value destructive to the multi-plan shareholders, or to the SPAC shareholders. So from that standpoint, while it's a case by case basis, I think you'll see, and I've already had conversations with a lot of lawyers about this. I think you'll see people having more and more conversations about the potential benefit of appointing a special committee to evaluate these transactions, and potentially even making a recommendation with an outside advisor and fairness opinion.
All right, James, I think with that, we'll go ahead and wrap up. Final thoughts for our audience, or anything you want to leave them with as we close?
No, I think we've covered it. Thank you.
Fantastic. James, it's really been a pleasure getting to pick your brain today on what SPACs can learn from the MLP playbook, and doing a higher level comparison between the viability and some of the issues around legal protections when comparing IPOs, SPACs, and MLPs. Again, folks, if you want more information on this subject, James wrote a great article titled, "Should SPACs Take a Page from the MLP Playbook?" You'll see this on our website, opportune.com. And again, folks, we've been chatting with James Hanson, Managing Director for Opportune Partners, the broker-dealer affiliate for Opportune. James, if folks want to get in touch, or they want to source you for some other insights on the topic, how can they do so?
Yeah, definitely. All my contact information is on our website, opportune.com. And I look forward to discussing this with people.
Fantastic. James, really appreciate your time. Thank you again. And we'll be in touch, and looking forward to sourcing you on the next episode.
Yeah, thank you, Daniel.
And thank you, everyone, for joining us on another episode of E2B, Energy to Business, on Opportune Podcast. If you like what you heard and saw today, and you want some previous episodes, or you want to make sure you're all caught